to another episode of Access Austin. In this episode, I'm going to be covering the Domino's Pizza lawsuit, and I'm really going to be talking about their case and how it was rejected by the Supreme Court. The Supreme Court elected not to pick it up, which was very much expected. This is not like a landmark deal for many people in the accessibility space. I actually watched several experts and they were saying they were very confident Domino's Pizza would lose their appeal to the Supreme Court. But I'm really going to be looking more at a general view of why accessibility for businesses is becoming a bigger deal and getting on the radar. So the first thing I want to really talk about is that accessibility lawsuits are on the rise. The data shows that in 2017, you had roughly around 750 lawsuits. So you had 750 2017, you have now 2,000 something for 2018, like 2,224, something like that was the number. But basically, then you go into 2019 and it's expected to even get higher than that. So you've seen a doubling from 2017 to 2018, and then even that being sustained in 2019 and going even higher, and it's expected to continue to rise. Now, the reasoning for this is that a lot of the internet is inaccessible. You're looking at roughly 70% of the internet space right now is not accessible to people who are screen reader users. People with disabilities who have like a visual impairment, people who need captioning, people who maybe need to be able to zoom into text, need contrast ratios, all sorts of things that where you need like a high contrast mode, different things like that need to be addressed, along with people, for example, who could get migraines and seizures because of the transitions being used and things of that nature. So there's so many aspects out there that are not fully being addressed by businesses, and particularly when it comes to consumer businesses. So like if you're buying things from like Amazon or something like that, looking at all the online marketplace retail, you're talking about a loss, meaning people have lost money because the user tried to purchase something and they were unable to do so. They wasted some time on that and then they couldn't finish that purchase, like trying to buy a pizza from Domino's. That money is in around $6 billion that businesses have lost because their stuff was inaccessible. And Domino's argument basically was that, this is not under the ADA, we don't need to do this, and they really were pushing for a lateral ruling saying that the Americans with Disability Act does not cover technology. It's not part of what's considered a public accommodation, which is the actual usage in the ADA, and therefore we don't want to make our stuff accessible. That was really what they were trying to argue, and the reason that that's a very flawed argument is for a couple of reasons. One is the ADA was founded around 1990 when the internet was not a big deal, obviously, so they had no idea about the internet accessibility and what was going on, but they did make very clear that areas of public accommodation need to be accessible, meaning could be physical spaces, but it's also being more and more applied to digital spaces, being accessible because that's areas that people go to, that people are expected to be able to use. You go on, you expect to be able to use the app to order a pizza, to buy something from Amazon. And as well, the mobile apps along with the internet itself, like going on web pages and stuff and being able to purchase things. So keep that in mind as one reason. The other thing is that what the courts have really established is what's called a nexus connection. So there's lots of state courts right now making rulings. There's no real federal overall guidance, which is why it really varies state to state. But some states have kind of went to this nexus viewpoint where there's some connection to a physical place. For example, if you're trying to buy something from a store, like for example, Winn-Dixie, because there's a Winn-Dixie lawsuit as well, that they were sued because some of their online stuff was not accessible and they had to make it accessible. So that's an example. You're adding something to your cart from like Amazon, Winn-Dixie, some type of store, and you can't actually do that. Well, then you need to you need to be able to do that because there is a public accommodation there is a store that you're trying to go to and access, and therefore the online is functioning as a part of that store. So I hope that kind of makes sense, that there's a connection between the online space and a physical place. That is one way the courts have kind of justified, okay, you need to make that accessible. However, that's not what all courts think. In fact, when you look at Netflix was sued and forced, they lost their suit, and they were required to provide captioning. That's why we have captioning on Netflix, and why we're seeing captioning becoming more and more prevalent and required for, colleges and universities, whatever content they're putting out, but also for businesses in general, like Netflix and Hulu and such. And the reason is that the Massachusetts court said, yes, Netflix, you don't have a physical space, which is what they were arguing. We don't need to do it because we don't have a physical space. But what your site is a space of public accommodation. Everybody who's going here and watching movies, and you're totally excluding people who are deaf and hard of hearing. So because of that, I'm ruling that you need to put, captioning. I don't like using the word force. I rather say, you need to do this, because they're in the wrong, and it's not, and it's just basically required. I mean, that it's necessary. It's the same way of segregation and those type of things. They're excluding people for no reason. And now we get captioning, and they're even starting to look at putting audio description for people with visual impairments, so they're able to engage in video content as well. So I think that's all really great. But the thing is, there is no guidance right now from the federal courts. And I think that is fair as an issue, because it would be helpful to have an updated ADA that had specific guidance and guidelines about what is expected for the companies, because it's very difficult to create something that is meeting every possible standard. So therefore, a lot of times companies are saying, well, it's very hard for us to make sure and guarantee everything's 100% accessible. But I think when you look at what the legal advice is, a lot of times what it's about is having in place a way for the consumer to be able to express when they notice an issue, and to have that issue remediated as quickly as possible. And having that process in place can really protect you from a legal standpoint. So for example, if you have on your website, if you notice an accessibility issue, we will respond to your message within X number of days, let's say 48 hours, and we'll make sure to address whatever you say within a reasonable time frame. And then you could, depending on what the issue is, you can try and address that. That is a really helpful policy to kind of have. I hope I'm not going too much into the weeds with this, but I really wanted to kind of just give some background and some ideas about what's been going on in the space. So when it comes to the Dominos case, they were looking for kind of a unilateral ruling from the Supreme Court to say no one has to make anything accessible, and basically segregation, excluding people with disabilities is totally fine. That's what they wanted the Supreme Court to say, and the Supreme Court rejected them totally and said, we're not going to take up your case. We're not going to deal with that. But I just think eventually we will need some guidance on what the standards are and what is expected. Hopefully we will see further adaptation. We've seen more in the legal settlements adapting WCAG standards, and I think that will become more and more prevalent. Web content accessibility standards, right now they're at 2.1 is the standard list about what the different elements of the website need to be accessible. So I think that we may see that be adapted eventually. Those are kind of just some overview thoughts that I have, and I just wanted to share. Please let me know your thoughts in the comments and suggestions. Thank you so much for watching, and I hope you have a great day. Thank you for watching Access Austin. My name is Austin, and I work full-time as an assistive technology coordinator, and I am dedicating most of my free time to producing content for this YouTube channel. If you are enjoying the videos, please consider becoming a Patreon backer. The link is in the description. If you have any accessibility needs or questions relating to assistive technology, accommodations, or website and PDF accessibility, please contact me at accessauston@gmail.com. Thank you so much for watching, and please like, comment, and subscribe, and tune in to the next video.